Hey, good morning, everybody, and great to have you all in our first of our StratConnect's Lift As You Rise webinar series. And StratConnect is a platform to connect SMEs that think global and act local to engage on those matters that impact the things that StratAstute Consulting advocates. And those includes responsible business, for good initiatives, and accountability activism. Just to give you some background, the idea came about when I started off as an entrepreneur with my consultancy and realized how lonely the entrepreneurship journey can actually get. As a result, in consultation with an associate who's actually joined us on the call as a participant today, Paolo Juricic, we formed an association with our independent professionals called the Independent Professionals Mentoring Circle. And we ensured that it was quite a closed group of people, a small group, so that we could share our business thoughts and those things that kept us awake at night with each other in a safe, comfortable space. And it's been exciting to see how those businesses that are affiliated to the circle have really gained momentum over the last year, and also how the spirit of collaboration between ourselves has really helped each other in the business and also helped our clients accordingly. So welcome, and I hope that you're going to form part of that system. Just a little bit about StratAstute Consulting. It is a niche business consultancy based in the Nelson Mandela Bay, South Africa, and it advocates a collaborative approach to business with the aim of creating sustainable businesses. Today is the first of our webinar series, and we're talking today about the spirit of the law in the new normal. And today I am pleased to welcome to the panel Suzanne Britton and Andrew Meldrum. Suzanne Britton from Britton Renecke and Andrew Meldrum from Meldrum Attorneys. We'll meet them just in a few minutes after I contextualize what we're actually speaking about today. So what is spirit? Spirit is defined as a particular way of thinking, feeling, or behaving, especially in a way that is typical of a particular group of people, an activity, a time, or a place. So when we talk about the law, you may wonder, does something like this actually exist? When we think about the symbol of law, we think about the symbol of the scale. And the scale is either up or down, right or wrong, compliant or non-compliant, very much like the double entry accounting system that we currently have, and also the economic principle of equilibrium. What is the role of lawyers? Lawyers are usually the custodians of the very rules that comply and uphold our structures, systems, and how we function as a society and as businesses on this planet. In South Africa, alongside the Reserve Bank and the JSE, our courts are ranked quite high on the trust barometer. Before we entered into lockdown, we were focused on issues such as BOSASA, eagerly watching the Zondo Commission, and also discussing the very complex issue of land reforms. And now, during and after lockdown, as we re-enter into the economy or restart at level 3, the priorities have shifted, or have the priorities that existed before lockdown actually been amplified because now they've been revealed. So Suzanne and Andrew, I really am pleased to have you with us today. It's a pity that we can't meet in person, but things have gone digital. So hello, and introduce yourselves. Tell us a bit about who you are and also about your practices.
Morning, Roshni. Thanks everyone, and thank you to the attendees and welcome. We hope that you'll find our session insightful, and please participate, please engage. As Roshni said, my name is Suzanne Britton. I'm a commercial lawyer originally from Cape Town, the mother city, based in Johannesburg for the last couple of years. And this is really the base from where I practice as a commercial lawyer. My practice focuses on commercial law generally, company law, and corporate governance. So that's really the space that I operate in. Roshni often says that she thinks of me as a constitutional lawyer. And perhaps perhaps you are right. I think I've said that on more than one occasion. Because I also think that, even as a commercial lawyer and corporate governance lawyer, you got to also have the human element and think with your heart. and apply the law, so that it's practical and not only this austere rules-based approach. So that's a little bit about me.
Thanks, Suzanne. Andrew?
Yeah, morning, everybody. Thanks, Roshni. Thanks for the introduction there. And welcome to all the listeners. I'm a general practitioner at Andrew Meldrum Attorneys, and we deal with a lot of different matters, family law, personal injury law, but I've got a bit of a special interest in property law and obviously landlord and tenant issues. So that's something that's become quite a big issue during the lockdown, as obviously when you have an ongoing contract like a lease agreement, there's obligations that have to be followed on an ongoing basis. And then obviously when you have an event like the lockdown or, as a result of the pandemic, how do people deal with that? It's often, what they call a force majeure event. And that's something that we need to try and figure out how to deal with it going forward.
Great. So Suzanne, before we get into it, tell us a little bit about your Robben Island experience and why I do sometimes link you to constitutional law.
So, it's actually a very interesting story, and I shared with Roshni. I was sitting at my desk at Old Mutual, I'll give you a short stint, and I got a call from now the late and great Amit Katrada, and I thought it was a prank call. Because sort of how would anyone of that stature sort of know me and know me to find me at my desk in a corporate environment. And at the time, the island was going through a time of where our heritage status was being challenged by UNESCO, and they were looking for someone to assist them with reclaiming it or reinstating it. So there's more call to action. To me, at any rate, as a little commercial lawyer sitting down in Cape Town, and I took up the challenge and spent 9 months physically on the island. I know people often ask, if you haven't been to the island, is it an island? Does it exist? And it does exist. It's quite a, it's a space that's filled with so much history, and you can't not feel inspired to do more and to contribute. And I think to almost the theme of this webinar, to lift, as we rise. So I spent 9 months there, completed the task. Gratefully, I can say that our World Heritage status was reinstated. Lots of lessons, lots of learnings, Roshni. Very powerful space. And I think, where we find ourselves now with COVID-19 and the pandemic, I got to thinking about some of the qualities of why we are heritage sites. And one of the initial reasons why, the island, what the island was used for was, it was known as a leper colony, And so I don't know if some have seen the news reports, but there's been a lot of call for the fact that Robben Island, should be, a hospital should be built there, that we should have beds, for people who have the virus and who need to recoup. And my feeling on that, is that it's a fine balance, because we don't want to have the old association of that leper colony to be associated with that. So I think the Robben Island experience still makes me quite, makes me very aware, in times like this of the spirit of humankind and our spirit to overcome and the history. Yeah,
fantastic.
Taking me back there, Rosh.
Thank you, Suzanne, and thanks, Andrew, for your intros. So we've got all our participants on board and we can get straight into it. So, Suzanne, I'm mindful that you are legal practitioners and the law doesn't stop, but you're also entrepreneurs in your own right. You're running your own practices, and you don't have the benefit of a big law firm or associates or colleague to speak to during a time of such uncertainty. What have the lockdown implications had on your business, and also on your business in context of the fact that many aspects of the legal system had to close for a short period over lockdown?
Andrew, if I can kick off, because I think our experiences have been quite different. As a commercial lawyer, I don't have to go to court. I don't have to, the justice system, ticks on, and, I don't need to be a part of it actively every single day. My experience is quite different. And so I've been very lucky that I've been able to work remotely. I've moved all my operations back home. And I've been able to advise clients on various aspects of, for example, how to run their boards now that we've got COVID-19. How does that work? Your voting procedures and processes, commercial contract reviews I've still been able to do. But having said that, though, Andrew mentioned, leases and rentals. It's obviously, I've got space in Sandton City, office tower, and I've been affected, as a small business with having to negotiate rental remissions with my landlord, which, like with any other business, whether you're a lawyer or not, it's still a very difficult conversation. Having to look at the staff complement and saying, well, austerity measures have got to tighten the belt, where do we need to rationalize? So tough decisions that I've had to make in my business as well. But on the whole, I've been able to work. And I think the experience was a little bit different for Andrew.
Andrew, how was your experience during the past 10 weeks? Were you able to continue your practice?
Yeah. Well, we also had to move everything back home and start working from home, especially during level 5. But we do a fair amount of litigation work as well. And obviously there you need to be at the courts and you need to utilize the sheriffs. And even now under level 3, although under level 3 there is quite a bit of leeway, the courts are allowing for quite a lot of processes to be issued. You can serve and file. And also the sheriffs seem to be coming back on board. But certainly under level 5 and level 4, you're very limited with how you could litigate because you go to court. You were allowed to go to court, but obviously they were only hearing urgent matters such as domestic violence and COVID-related cases. So yeah, I think for litigation attorneys, it was quite hard. But then again, I think it's not a case of that work has gone away. It's just been postponed. So as the lockdown eases and the courts open up, that work should pick up again.
Yeah. And from an income generation point of view, I mean, you probably have been helping some businesses and some private clients over this time. We've all thought of calling our lawyer during the last 10 weeks at some point. And interestingly, the lockdown regulations, and we'll get into that right now, were at the level where even if you took your mask off for 30 seconds just to breathe some fresh air, you were in some way contravening an aspect of the law. Were you able to earn some income during this period? Were you able to bill your clients, and how did that work? Because you've also got your own operating expenses as a legal practice.
Mm-hmm. I mean, I've seen it. There was obviously a downturn in terms of work passing my desk. Even though I was able to work remote, it was definitely a downturn. I've only really seen an uptick in business in the last 2 weeks, really. And I think, because that's the economy is coming back. But during that time, it was, lockdown 5, level 5 and 4. It was definitely a slowdown of work. And I like to call it, pre and post COVID-19 rates. Generally, I think for the last 8 years, lawyers have definitely had to relook the way they bill, relook the rates that they charge at. But now with COVID-19, I mean, I've personally taken the approach that we're all in this together. We're all getting burnt. We're all hurting. And so you can't possibly charge, normal rates, even to regular clients. I've made there's a special dispensation for me with lockdown related matters or force majeure matters that we've had to advise on. It's almost been next to nothing, just really covering the basics so that we can all make progress. And then I've got new rates, for going forward as we all try and navigate and regain, some economic activity.
Fantastic, Suzanne. It almost sounds like a recalibration from your side, with the aim to do the right thing during this very difficult time for people and businesses. Andrew, on your side, have you had to adapt and adjust to a new normal?
Yeah, absolutely. I mean, I agree with Suzanne. There's definitely going to be pre and post COVID-19 rates. And obviously, with people not being employed, the whole economy is there's less money flowing through the economy in general. So, we've definitely catered to that. I've had a lot of smaller businesses come to me and even private individuals, especially with issues over the lease agreements and not being able to complete. And, there have been a few occasions where we've had landlords who've been just oblivious or unreasonable, in my view, to what's going on. They said, well, we're going to stick to the letter of the lease agreement, and that's that. But obviously, when those lease agreements were drafted, nobody could have foreseen, although we may have foreseen some sort of unprecedented event like a force majeure, nobody would actually have seen what we're going through now, especially on an economic lockdown. So yeah, there's been a lot of that. And obviously you can't, when your clients are coming to you, they're already in financial distress. You can't really then whack them with a huge bill. So we've been doing a lot of work like that, as Suzanne says, just to try and keep the ball rolling, keep the lines of communication open. On the other hand, a lot of the landlords that we've dealt with have been very reasonable, and they understand the situation. They understand that people don't have funds available. They're not even, in many cases, we weren't able to even use the premises that we were supposed to be renting. So, a lot of landlords have come in there and given some kind of discount, or even, some have delayed payments, and, there's specific agreements that have been put in place to deal with that.
Yeah,
and
so
others
Andrew,
have actually given a dispensation and discount.
So Andrew, let's go there. You actually have prompted or cued the next part of this conversation, which is around rental agreements, landlords, and bonds. It's an aspect that touches most of society. And in the statistics that came out this week, across 80,000 residential tenants who were surveyed, only 37% can afford to pay their rent in full during May, and 22% said they can't pay their rent at all. Of those surveyed, 32% of tenants indicated that they are likely to move down after lockdown purely because of affordability issues. From a concession point of view, landlords have accommodated 35% of rentals with reduced or waived rent. And interestingly, landlords who are individuals renting in their right have been more empathetic to the situation, been able to offer up to 44% of relief, whereas only 24% is a comparative of companies or trusts who are offering space to rent. In the commercial area, that's been a completely different ball game. The South African Rates Association, Property Owners Association, and the Council of Shopping Centres amalgamated or formed a collective to try and offer some sort of relief from April and May, some discounts, interest-free rental deferments that are going to start from 1 July onwards. So interesting developments. Then, of course, there was a lot of discussion and debate around the force majeure clause, which you alluded to earlier. Tell us a bit more, Andrew. So we're going to go into a restart. We're in level 3 now, and hopefully that improves to level 2 and 1 over the next few months, if all goes well on the healthcare side. And the issue, though, is that even businesses go back, that doesn't mean that they're going to be operating at full capacity, because there are cash flow constraints. People don't have that much to spend. There are retrenchments that are growing. How should we look at the whole space of rentals and commercial contracts from the eyes of the lessee and also the landlord?
Okay, Roshni, yeah, I think that's a very, as I say, it's a very important part of my work, is dealing with landlords and tenants. And often the force majeure clause is there in a lease agreement. And that's basically to deal with elements, obviously unforeseen catastrophes such as, it could be a flood or a pandemic like we have now, but nothing, it doesn't really, the force majeure clause in a lease agreement generally deals with the impossibility, an event that causes it to be impossible to continue leasing the premises in terms of actually occupying the premises. So, for example, if there was an earthquake, then, obviously the building is destroyed, for example, and then there's an impossibility to continue leasing the premises. And under those conditions, the landlord's obligations to the tenant are done away with. But now what we're seeing, what I'm seeing a lot of is that there's not an impossibility to occupy the premises, but rather an impossibility to pay the rent, basically, which the law does not actually recognize the impossibility of payment, unfortunately. So in our law, that is not something that a force majeure clause would actually deal with. It would deal with, as I say, floods and events that make it impossible to actually, be in the premises. But another aspect to consider is also the issue of whether or not the tenant is allowed the use and enjoyment of the premises. So, for example, under level 5, when everybody had to work from home, there was a good argument for the tenant to say, listen, we're not even able to use the premises anymore. Surely we should be at least given a reduction on our rental, And this is where, coming back to your point of the spirit of the law, I think it plays a very important role. Yes, you've got the black and white contract in front of you. But as I said earlier, no contract or lease agreement that's been drafted ever contemplated an economic lockdown of this nature. And so in a situation like that, the law has to be pragmatic, and you have to, mediate. And both parties, it's actually in the interest of both parties, both the landlord and the tenant, to find a middle ground, For example, if a landlord does want to be a stickler and, insist on the letter of the law, as it were, he's going to lose, he or she is going to lose tenants at the end of the day. And in an economy that's already depressed, that may not be a very forward-thinking way of dealing with the issue, because you may lose those tenants who were unable to pay because of the lockdown. But what guarantee does that landlord then have that they will get new tenants anytime soon? So they may end up sitting with a premises that's just empty, in which case they're almost cutting their nose off to spite their face. But as I say, the law is very often pragmatic, and in my experience, majority of landlords and tenants have been able to reach some sort of compromise, whereby there is some sort of rebate on the rental, and the tenant is given some relief by the landlord.
Andrew, there's an interesting question from Dr. Dennis Farrell out in George, saying, what is the tenant's position should a landlord not respond at all to cautionary notifications over the COVID-19 period, that a business will not be able to continue and hence cancel the rental agreement? So what do you do when your landlord simply doesn't respond at all and the business is really battling for survival and potentially on the brink of thinking about closing their doors? Yeah.
I mean, it's a strange scenario in a sense that the landlord is just not responding, because in my experience, 99% of the time the landlords are they prefer to actually speak to their tenants than, and have that open dialogue, But I mean, what I would suggest in a situation like that is just practically speaking, keep everything in writing. Make sure that when you contact the landlord, send it through in an email. Don't just leave a voice message or something like that. Make sure it's something recorded, and just cover yourself. At the end of the day, the law is reasonable, and that's what we aim for. That's one of the main principles that you'll see in case law when a judge is looking at a matter. Yeah. They apply the principle of reasonableness. Yeah. We saw that earlier this week in the De Beer case, which the High Court just handed down. So as long as the tenant is being reasonable in this situation and doing the best that they can to comply, and also keeping a solid record of everything, I think that's the best way that the tenant in that situation can protect himself.
Right, Andrew. Thanks very much for that. And in that instance, do you feel that it would be prudent and perhaps the right way to go to channel such communique via a lawyer? I've worked with some SMEs who've come up with this exact issue, and my suggestion has been, can you perhaps rather keep your lawyer informed in case the pawpaw does hit the fan, so that they are aware of what steps you've taken. And I've also found, without going further into this point, is that the words and the language that one uses, it's quite important, because as much as it's a contractual matter with the landlord, it's also a matter around insurance clauses, etc. So would you echo that, Andrew, or do you have another suggestion?
Yeah. Sorry, Roshni, I didn't catch the last part of the question. Can you just repeat it again?
Yeah, sure. So I'm asking, would you recommend that the correspondences go via an attorney for the purposes of record and terminology? Or are you quite comfortable that if it's sitting in my outbox or in my correspondences files, that should cover me if something does go wrong?
Yeah, look, obviously, as a lawyer, I suppose I'm going to recommend people go through lawyers, but I do think that it does have an effect. I've had a couple of clients recently with these kind of issues where, they've been not ignored by their landlord, but I would say bullied by their landlord. And the minute they've got a lawyer on board, all of that bullying and, the irrational thinking and that has been put to one side. And obviously, I think having two lawyers involved, because obviously then if the landlord has a lawyer and the tenant has a lawyer, that takes away the emotional aspect of it as well, and it allows the parties to maybe find a far more reasonable meeting point.
Thank you, Andre. I see your question, and I think we're going to get into it as I ask Suzanne to tackle the next one, which we've seen really interesting developments as recently as last evening. The Pretoria High Court ruled the lockdown regulations as unconstitutional and invalid. Quite a strong judgment. Judge Davis mentioned that some of the regulations failed the rationality test. This pierces a deep wound of systemic mistrust in South Africa that has actually been festering over the past 10 years with the issues that we've been trying to grapple with as a society and heal, and not only in the public sector. Earlier or before lockdown, we were also focused on the whole Steinhoff matters and some corporate issues that have come up. Last evening, former public protector Thuli Madonsela stated that she would not be surprised if a higher court applied a bit more scrutiny to the judgment that was handed down. Suzanne, you pointed out to me a really interesting speech made by John F. Kennedy at UCT in 1966 about trust in the system, particularly in South Africa. And that just kind of moves my mind to what's happening in the US at the moment. And I can't help but think that the US is starting to face similar issues of diversity, racial tension, just at a bigger scale because they're a bigger society. So in a society where the trust between business and stakeholders is inherently so low, and what happened over lockdown with regulations that were considered to be overly stringent and completely impractical in some cases. Suzanne, how do you read that? And what, from your legal perspective, were your thoughts around this?
Before I weigh into that question, I just actually wanted to tie in with what Andrew was saying, maybe just a closing comment on my side to Dr. Farrell's question. I think that, even if your landlord has ignored you to date, your starting point is your contract, and you'll often be surprised that sometimes there are loopholes in your contract that you can actually rely on to forward your point. The other thing is that, as much as people get excited about litigation, I'm always for a negotiated settlement. And I think that people are going to find more and more that that's going to be, the objective. So don't lose heart. I think you've got to stick to your guns. I think you've got to continue, putting everything down in writing and making your point. But the ultimate goal is to come up with a negotiated settlement. So think about options commercially so that it's a win-win situation for both you and the landlord if you are cancelling. So just a point from my side. Roshni, to the question, very loaded question. The judgment is fresh. It's been critiqued by constitutional experts such as Pierre de Vos. I love his phrase, constitutionally speaking. I'm not a constitutional lawyer, but my feeling has been that our rights have been suspended during this time. I think everyone was gung-ho, and willing to make the sacrifice for the first sort of 21 days, or I can't remember how many days it was. I think we were all in it. We needed to make the sacrifice. It was for the greater good. It was to flatten the curve, and we were willing to take restrictions, on our constitutional rights. I think post that, my feeling is that it's become a little bit arbitrary, and that's my personal view. It's become a little bit arbitrary because I haven't seen, a scientific report, coming from the president's office giving us reasons. The regulations have been coming out fast and furious and very erratic. So definitely there's been a suspension of rights, but for me, there has not been a suspension of our Constitution. The rights enshrined and ingrained in our Constitution remain and prevail, and they should be. Our Constitution has been lauded for being one of, the best constitutions globally, and that remains. So that for me is fundamental. I think that, as much as we've got a constitutional crisis, let's call it that, we are going to see a lot of challenge and this current, the De Beer case, I know the minister and the advisors are still scrutinizing the judgment before they respond. I'm encouraged, and I'm actually encouraged that we've got a constitutional democracy. And maybe that's because I'm really positive about the country, no matter what we're going through. I'm really encouraged because, and why am I positive and encouraged by this? And why am I even encouraged by this judgment? Even if it goes on appeal, and I think in all likelihood it will go on appeal, the judgment was sort of dealing with various things. Like I said, it started off with a quote, with Robert Kennedy's quote in 1966, at UCT. It sort of spoke about the spirit of Ubuntu. It spoke about very sort of personal issues, a single mother, who's a hairstylist not being able to go to work. That's not rational. And there's a lot of emotion almost in the judgment, the way I read it, But I'm encouraged because it can be challenged, and we have the right to challenge. That for me is what a democracy is about. I don't think that we should lose hope. I think that our law, I see Andre Young's question, is the law created for these times? I think that even the Disaster Management Act didn't contemplate this type of pandemic. It contemplated, disasters, but not this type of pandemic, and not the way it's playing out. But having said that, though, the law is there, and I think it's robust enough where we can take an interpretation and apply it practically. We've got our Constitution. So just, even the Constitution, for example, we've got all of these rights. But even Section 36, says that it can be limited in certain circumstances. What type of updates on the law do we have that things make sense for these times?
Okay, so we'll get to the questions a little bit later, yeah. Suzanne. I want to move on to the aspect that impacts companies and businesses, whether you're a listed company or a private company. or even an NPO or a sole proprietor. Corporate governance is something we should all be striving to, and it's the balance between doing the right thing, i.e. by the rule of the law, against, and I don't want to use the term against because it's not one or the other, it's both, versus doing the right thing. And that is about governance, it's about ethics, it's about the spirit of the law. But yet we've got AGMs to run, we've got statutory reports to submit, etc. How did this play out during lockdown? How are the courts seeing these requirements? How are your professional bodies, for example, like the JSE, like SARS, looking at this whole, business unusual, where your financial accountants possibly hasn't been at work. Someone hasn't been able to review interactively and sign off. There's probably been a change in the delegation of authority. Your systems check, your internal controls have had to shift and adapt very quickly. And it was impossible to audit as we go to ensure the utmost validity of what's going on. Tell us a bit about statutory compliance requirements, corporate governance requirements, and also the returns that we still have to all submit.
Perhaps just a step back before I launch into that. I think that, what we've seen is that, what is all of this highlighted? Perhaps that's the question that I got in my mind just as I move into the specifics. The pandemic, has shone a light on the fact that, we do have laws that can cater for these things. But what the pandemic is not able to wipe out is corruption, for example. We've seen, for example, PPE equipment being intersected or confiscated on their way to a KZN school. We've seen those elements. We've seen price gouging. What I'm encouraged by is the fact that we do have enforcement. Our laws are able to be enforced. The Competition Tribunal, clamping down hard on price gouging, for example. Coming back to corporate governance, the one thing I do want people to think about is that we shouldn't neglect corporate governance at this stage. Yes, we have a lot of priorities as small business. Yes, we have a lot of, bigger issues than the softer issues to think about, but I want people to be encouraged to consider, for example, boards are no longer, in my experience, there's physical distancing and we've all had to move to Zoom meetings. So electronic communications is there. Our Companies Act makes allowance for that, for board and shareholder meetings to be conducted entirely electronically, provided that everyone can participate concurrently and everyone can vote and you can still engage. So as much as there's that allowance for this, we need to make sure that we still meet the other conditions and parameters. The other debate, for example, at the very start during lockdown 5, there was a big debate around whether dividends that have been declared by companies could and should be paid out. My feeling on that was, well, the rule is very clear. The rule says if you've declared a dividend, you must pay it out. Yeah. But it was very interesting to see how, as lawyers, there was a whole lot of debate around that rule. And the JSE weighed in and SARB weighed in, and ultimately the decision was taken that the rule exists. Let's apply the rule. But my feeling is that with COVID-19, that rule may very well be reviewed. I may be wrong, but I think it may very well be reviewed because a lot of companies didn't apply the rule. Yeah. They stepped back and they said, that's the letter of the law, but we're not going to apply it because of our circumstances. Yeah. The other thing that I think is important to consider is, has your board, look at the constitution of your board. Look who serves on your board. It could be one person, it could be 3 people, it could be 7 people. Has that board been able to operate effectively and been able to make effective and fast and quick and hard decisions during this time? If not, now's the time to actually review the constitution of your board, look at the mix of skills that you've got on the board and make some changes so that you do start preparing, even as a small business, if you've been owner-run and you're only one director, you're the shareholder and the director, you've had a lot to deal with during this time, and you've had a lot of decisions that you've had to make. And perhaps now's the time to get a non-executive director on board. Someone that you can lean on, who can look at it objectively, and so that you can lead your company ethically, efficiently, and compliant, and so that you can plan for the future. Because for me, corporate governance is not only about strong leadership, but it's also about ethics and also credibility. It brings in that element. And COVID-19 has showed us that there's a big reset, and a lot's been reset. And now's the time to, take a new broom and start sweeping clean and where you need to. Have you got proper decisions in place? Are you having robust discussion? So that's the kind of thing, Roshni, for me, that I think that we need to start looking at, and that we don't neglect corporate governance, even as small business.
Yeah, Suzanne, I'm encouraged to hear what you're saying. Despite business unusual and the unprecedented nature of this pandemic, corporate governance is a must. It's a brick in your foundation you cannot remove at any one point in time, even if you make it that much more practical. So, I sit on audit and risk committees, and we've had intense meetings over the last 10 weeks, more frequently than usual. That's the first thing. Our packs were all sent through electronically. It was really hard trudging through 400-500 pages electronically, and not having the means to print that volume out. But worked really, really effectively and efficiently. So company secretaries that I certainly have engaged with have done a fantastic job to respond to this. And it was all those things that we were discussing as boards and non-executive directors beforehand that have actually been accelerated and put into practice now quite successfully. And the virtual or online AGMs are working quite well from those that I've heard. I think from an SME perspective, we often think of corporate governance as a theoretical of a high corporate requirement, but most certainly the more unsure things become, the more important it is that you are putting extra measures in place to ensure that you are doing the right thing, and also that you're doing things right. And, for me, we've come to a time where almost your accountants and your lawyers have to start forming a closer collaboration to start thinking these things through. It's not a matter of applying the IFRS principles only or the law only. It's about business sustainability, and then it becomes a little bit more gray. I'm mindful of time, so I'm going to get into the closing stages then. SMEs don't often have the means for high quality legal advice, and legal compliance is often managed as a reactive service. I'm an advocate of legal compliance management as a proactive service, so that the total cost of your legal costs are kind of reduced over time, and so that you make sound business decisions up front. Andrew and Suzanne, times are rough. Cash flows are really, really tight, but the complexities around what happens to contracts, how enforceable they are, how practical things are, as Andre was saying earlier, becomes vague. And so we need to call on lawyers. How can SMEs do this affordably without compromising the quality of the service that they're getting?
I mean, Andrew, happy to kick off. Yeah, for me, it's. I always say that your lawyer is not just a service provider. And that's my approach to practicing the law. We've got to partner with our clients, and it's about long-term investment. It's not just about short-term gains, and choose your lawyer wisely. Choose that partner wisely, because then you can have courageous discussions to say, I can't afford this. I would still love this, and the lawyer as another business person needs to have the discussion to say, I can take this on board and let's compromise and reach some arrangement. I think that the time for lawyers sitting on pedestals and not being in the trenches with clients has come and gone. Yeah. We're all in this together. We're all hurting. And I think it's to have the courageous discussion and to meet each other halfway.
Thanks, Suzanne, for that. Andrew, you've made the big move from Johannesburg to Port Elizabeth, which is a completely different business context, different levels of rates, different levels of affordability, and different types of cases that come to the fore. Maybe let's hear from you your practical experience. How have you adapted your business? And if you had to, for example, give advice to an SME, how would they go about obtaining legal advice that is right for them and also affordable for them at this time?
Well, yeah, I mean, I agree with everything that Suzanne's just said. I mean, you need to find a lawyer that fits with you. Not all, it's horses for courses. So seek out an attorney that you feel comfortable with, that you can talk to, and a lot of the smaller firms are not as expensive as the big firms, but you're not necessarily cutting down on quality. You still may get a quality service at a lower rate. But also when it comes to rates, one of the things that the Legal Practice Council has introduced quite recently is that attorneys are obliged to give an upfront cost estimate to their clients. And that's something that, I think should be done across the board. I mean, that's what the Law Society, the Legal Practice Council, that it's called now, is saying must be done. So you can have that discussion with your attorney up front and say, look, this is what I need to be done. What am I in for? What is not necessarily an hourly rate, but what is this going to cost me all in from, to achieve this outcome? What am I looking at? And as an attorney, it's very difficult at times to give an exact figure when it comes to pricing, because obviously we use service providers like sheriffs and sometimes advocates, and we don't know what they're going to charge. But we can give a ballpark figure so that the client knows up front what sort of amounts they're in for.
Thank you, Andrew. I mean,
so there's always, there are ways around it, and I think that, yeah.
So thank you, Andrew. I mean, I've worked with both you and Suzanne across my clients, and I've certainly found, your approach to be quite sensible in terms of let's look at what the situation is and try and find a solution that gives the client what they require in a practical manner. So let's not give them overkill, but also in an affordable manner. So great. Suzanne, if people want to get hold of you, where can they contact you?
I'm on LinkedIn, I'm on Instagram, I'm on Facebook. My email address is suzanne@britainrenecke.co.za. Our website is www.britain, it's spelled like the country, so BRITAIN, Renecke, RENECKE.co.za. Please reach out. You can find all my details. Don't hesitate to WhatsApp if you've got a question. To Andrew's point, to Roshni's point, not everything is billable. We're also here to find solutions and to help each other recover from all of this. Thanks, Roshni.
Thanks, Suzanne. Andrew, where can people get hold of you?
Yeah, we're also on LinkedIn, on Facebook. Just search for Andrew Meldrum Attorneys. We have a website. It's www.meldrumattorneys.com, not .co.za, but .com. And then, you can give us a ring on 041-101-1115. And just give us a shout. We're always open to have a brief discussion over the phone. And we can see if we're able to assist.
Well, fantastic. Suzanne, Andrew, thank you very much. You are both passionate lawyers in your own right. And I've invited you today because you're also for good lawyers. That for me comes out every time I have a conversation with you, and it really is energizing because it is about collaboration. And if we're going to be assisting businesses to sustain, we're absolutely all in this together, as they say. We had just under 20 participants on the call today, so thank you for sharing your virtual coffee time with us today. It was great being with you. And from StratConnect side, we're going to try and do this once a month on about the 15th of each month. This month is a little bit different because it's our birthday month. So we're having another webinar on the 9th next week where we'll be speaking to Sharon Maniaka, Dr. Dennis Farrell, and Wade Bolton on a very important and arising issue of employment and employability in the new normal. So thank you. Have a great day, and we'll catch you the next time. Bye-bye.
Thank you. Bye-bye.
Roshni, bye-bye.
Bye.
Bye.